Hey class, here's Mr. Stewart. This is going to be the Chapter 6 Integrity video. We did not have one for Chapter 5, so back again this week here for Chapter 6. Now I intentionally kind of waited a little later this week to get this video posted because I wanted you to read this chapter and look at those discussion questions before I went into some of the explanation of this stuff. So hopefully I'll be able to clear up any mud. I'm really not going to comment on a whole lot that's in this chapter, but a couple of the main points just to make sure you understand those. Of course, the chapter goes into some fairly deep detail in regard to each one of these concepts, and of course I'm not going to go over every one of the slides that's on this PowerPoint either in the lecture. Of course, you have the PowerPoint, you can look at the PowerPoint, you can go over the slides, but one of the things that we're going to be doing is talking about, in this chapter, basically what judicial notice, witness privilege, and shield laws are. And I'm going to refrain from commenting on my opinion in regard to shield laws because I've asked you for yours in the discussion board this week. So, first of all, of course, you can read those learning objectives. But I want to talk about judicial notice. And what judicial notice really is simply a shortcut for the court, because there's some things that you're going to ask to be brought in as evidence in a particular case that's already been proven to be fact, either through other trials or through scientific research or through other means. That we already know that maybe these things are uncontroverted facts. We just have to kind of stipulate to the court that this is applicable, it's relevant and material in this case. So really what judicial notice is a shortcut to allow some of that evidence to come into court without us having to actually prove every single thing, because then trials would take a whole lot longer. They'd be a lot more expensive, and the backlog of cases would just be huge. So judicial notice relieves parties in criminal and civil trials from the duty of introducing witnesses, documents, and other evidence to prove some sort of uncontroverted facts. And basically what it is both sides agree that something is what it is. Both sides will stipulate to the court. Says the parties to trials may also use a joint stipulation to stipulate to certain facts or for trial purposes making proof of such facts unnecessary. So if both sides agree that some fact or some set of facts is true, it is the way that they say it is, then we don't have to prove those things. We can just shortcut those into the court and they come in as evidence and the jury can see that. This can also be done by the judge. The judge can just recognize certain things being as what they are. For example, if you have a murder trial and you have DNA evidence, you do not have to prove in every single murder trial that DNA evidence is good evidence. It's for the most part irrefutable evidence of identification. You do not have to prove that. That would be stipulated or simply just acknowledged by the court. The court would take judicial notice of the fact that, hey, DNA evidence is good evidence to have. Now, you may have to prove how you got the specific DNA evidence from a victim or from a suspect, and you may actually have to show how they match, prove how the two samples match, but you don't have to prove that DNA evidence is admissible and it should be used in court for identification purposes. Hopefully that makes sense to you guys. So some of the common examples of the use of judicial notice to prove matters of general knowledge, establishing the sex of a witness or a defendant, establishing the meaning of words or phrases or abbreviations used commonly on the street, the location of things, well-known habits, etc., etc. Things that people just know. You don't have to introduce a photograph to show that there's a clock on the top of the courthouse. People that are from that area will know there's a clock on the top of the courthouse, and the clock dings every hour or every 15 minutes or whatever it does. And that might even be helpful in a case if somebody is saying, well, I heard the courthouse ding 3 times. So I knew it was 3 o'clock, and that was right before I heard a scream, or right after I heard a scream, and then I went and I found somebody dead. So it would be an uncontroverted fact that the court has a clock and it dings. So you wouldn't have to introduce photographs of the clock, or an audio tape or a videotape of it dinging 3 times at 3 p.m. That would be something that the court would just take judicial notice of and say, yep, we understand that. Move on. It has been held that courts should not take judicial notice of facts that are an element of the crime charged or serve as the basis for increased prison sentence. So, even if some things are general knowledge, if you're really using that as part of the proof of the element of the crime, or you're trying to use it to get a more severe prison sentence, then that's going to be something you're just going to have to present in court. They're not going to take judicial notice of that. A court may also not take judicial notice of a fact solely because the fact is well known to the judge. It has to be commonly accepted. Just because that judge believes it and knows it doesn't make it able to be used under the umbrella of judicial notice. So, we have to look at those commonly held facts. It's kind of like that definition of reasonable that I gave you a couple weeks ago. If you presented the same set of circumstances to any Tom, Dick, or Harry on the street, they would likely come up with the same conclusion. Well, judicial notice is very much like that. This is something that the majority of people, or at least the majority of people in a particular community, would have to be aware of before judicial notice could be taken of something. There's some court cases here. Make sure you read State versus Harvey. It talks about judicial notice. U.S. versus Mariscal. Another case there. As far as judicial notice of facts obtained from sources, a court may properly take judicial notice of facts cited in any of the following: recognized reports, learned treatises, dictionaries, or simple data printed in newspapers. We don't have to prove those things. We could have that a newspaper article entered as a piece of evidence because now it's been published and people have had the opportunity to read it. Then that would be considered a commonly accepted fact or set of facts. Or if something is published in a book, if it's in a dictionary. Now, I'm not talking about a fiction book. I'm talking about a nonfiction book or some sort of research data or dissertation or something like that. If something has been kind of like peer-reviewed, you guys should be familiar with peer-reviewed sources. That'd be something that the court could take judicial notice of. Judicial notice can be taken of a court ruling that a scientific theory or technique is reliable. And that's what I was talking about in regard to DNA a few minutes ago. And that, understand that when DNA first kind of came on the scene, many courts rejected it as junk science. They said, there's no way that can be true. And it took a lot of wrangling, if you will, before a judge finally accepted it. And then the interesting part is once a judge somewhere looked at the data, accepted DNA evidence as reliable, material, and relevant to the case, then other courts could then refer back to that first court and say, well, it was there's a precedent that has been set, if you will, that this court somewhere else at some other time accepted this, took judicial notice of the fact that this is acceptable and admissible, so we're just going to ask that the same thing happen in this case in order to keep from reinventing the wheel and to take a shortcut, if you will, in the trial process, because trials typically are long and drawn out anyway. So if we can take some shortcuts on generally known or commonly known facts and just have the court take notice of those and that recognize that they are material, relevant, and admissible, then I think that's a fair way of getting some of that evidence in court. So in a nutshell, that's judicial notice. It basically is just a way for the courts to be a little bit more efficient and to not have to prove every single thing. If it's already been proven somewhere else, or it's commonly known information or generally known information, then it can come in. Next thing I want to talk about here for just a minute is the privilege against self-incrimination. This is what we typically refer to as taking the fifth. Understand that no criminal defendant in any criminal case in the United States can be compelled to get on the stand and testify on their own behalf. They do not have to testify. And if the criminal defendant decides not to testify, they also will not be compelled to be cross-examined by the other side. But, for example, if the defendant decides not to testify, then the prosecution doesn't get to ask that defendant any questions at trial. If a defense witness decides not to testify, then the prosecution also does not get to cross-examine that witness. If a prosecution witness decides not to testify, then the defense does not get to ask them any questions either. And the jury can kind of draw whatever conclusion they want to draw in regard to witness testimony or failure to testify. Sometimes we can compel witnesses to get on the stand, and then we give them a chance to lie or tell the truth. But a defendant, the actual person who is charged with the criminal offense, cannot be made to get on the stand and testify if they choose not to. Also understand that the jury is instructed to not be prejudiced against that defendant for not testifying, and the reason is because that's a constitutional right. You do not have to testify on your own behalf. You do not have to testify. If you're charged with a crime, you don't have to say a word, because guess what? The burden of proof is not on the defendant. The defendant does not have to prove themselves not guilty. The burden of proof is upon the prosecution. So the prosecution should be able to prove their case without actually having the criminal defendant say anything. So the Fifth Amendment privilege against self-incrimination is the only privilege that has been incorporated into the U.S. Constitution and also the Constitution of many other states. The U.S. Constitution requires that the government seeking to punish an individual produce evidence against him by its own independent labor, rather than by the cruel, simple expedient of compelling it from his own mouth. So we can't make you say anything that could potentially be incriminating. And the prosecution hates this because they want the defendant to get on the stand, so they will have the opportunity to try to catch that defendant in inconsistencies or lies or destroy their credibility. The defense in many cases will implore that the defendant not testify just so the prosecution doesn't get a crack at them to poke holes in whatever their case is. So just understand that is a constitutional right, and you do have this privilege. It is a constitutionally guaranteed privilege that suggests that you do not have to testify on your own behalf. Now, there are some exceptions to it. So the Fifth Amendment privilege against self-incrimination applies only to evidence of a communicative or testimonial nature. If you have other physical evidence that's been provided by that defendant, that can be brought in without any issue whatsoever for the most part. I mean, or if there is any issue, it's from another angle. It's not about this privilege against self-incrimination. It only applies to materials or documents in which the person invoking the privilege has sole possession. So if they have something and they're the keeper of that information and nobody else has that information cannot be compelled to be admitted. Because the only way it could be admitted is from the person getting on the stand and testifying to what's in the documents, and then the documents would be admitted at trial as well, along with the testimony. However, if other people keep the same information, then that information could be admitted at trial, just not from that person who is pleading taking the fifth, if you will. The Fifth Amendment also does not apply when only physical evidence is sought and obtained, such as withdrawing blood and using it as evidence or using a handwriting sample as evidence, etc. Here's some other, on this slide, some other reasons or exceptions to the Fifth Amendment privilege. Compelling the accused to exhibit his person for observation, as in a lineup or a show-up. We can make them stand in a line or take pictures of them to show potential witnesses for identification purposes. They're not actually saying anything. They're simply just being observed one way or another. That's not a Fifth Amendment privilege. Taking a voice sample doesn't apply. For ID purposes, to put on a stocking mask at trial and permit a witness to testify as to the similarity to the masked robber, or to dye his hair the color it was at the time of the offense. Yeah, we can compel them to do that. Testimony of a witness that the defendant was compelled to put on an item of clothing or shirt and it fit the defendant, such as OJ. OJ was made to put on the glove that allegedly was worn at the time of his wife's murder. And of course the mantra from the defense was, if the glove don't fit, you must acquit. Well, interestingly enough, OJ put on enough of a difficulty show while trying to put the glove on. The jury didn't really believe that the glove fit OJ's hands. When in fact, I could probably put on the same show with a glove that fits me just fine in any other case, and I could probably try to make the jury believe that that it didn't fit me. You know, you can figure that one out. Also, where immunity has been granted and the person is compelled to testify or agrees to testify as part of a plea agreement. If we are promising you immunity, the prosecution, I mean, and then you decide to take the Fifth, guess what? Immunity dies with the time that you decide not to testify, and then you could be criminally charged at that point. So keep that in mind. If the defendant is a corporation or an unincorporated union or other organization, where the incrimination of others is not self-incrimination. And there's a bunch of other exceptions here, and that's the thing you'll find out in regard to criminal law, is that you'll have a rule and then you'll have a whole lot of exceptions to the rule. But typically, generally, and historically, a criminal defendant does not have to testify on their own behalf. They just don't have to. They can use that constitutional right, and the jury should not be prejudiced that they are not testifying on their own behalf. Now, that's a perfect world. Do you think that juries are prejudiced sometimes because a defendant fails to testify? I'd say yeah. I'd say they probably are. They even have been instructed not to be by the judge. But it's human nature. You would think that if you were accused of something, you'd want to stand up for yourself. And if somebody was lying against you, you would want to get out there and tell the truth. And I think it's human nature to believe that their failure to testify means they may be hiding something. And that very well may be true. But juries should also understand that that is a constitutional right. And if we make them testify and they don't want to, that really does shift the burden of proof away from the prosecution, which is a complete reversal of the way our criminal justice system works. So the burden of proof is on the prosecution. That's why we can't make somebody who is charged with a crime say anything. They don't have to say anything, because the prosecution should be able to prove their case through their own independent labor. All right, here's some more court cases. Crouch versus U.S. In re grand jury subpoena, 2009. Read that case as well. When and where the Fifth Amendment privilege does apply, the Fifth Amendment protection against self-incrimination becomes applicable when a person's statement or communication is compelled, testimonial, self-incriminating, or in any criminal case. So if it's any criminal case, you cannot be compelled to testify if you are the defendant. Make sure you understand that. Here's some other examples where the Fifth Amendment against self-incrimination does apply. Where the witness insists they're innocent, they don't have to say anything other than, I'm innocent. When a person refuses to answer specific questions on a tax return. When a person is questioned by a probation officer. If the questions are mandatory and not optional. Where a defendant remains silent under questioning, the prosecution is prohibited from introducing evidence of that silence at trial. For example, you get arrested and you get brought into the police station, they set you down and they're going to try to interrogate you, and you say absolutely nothing. Nothing. You don't cooperate with the police, you don't say anything. The police may not enter evidence at trial saying they would not talk to us, so therefore they must be guilty. They can't do that. And if they did, that should be stricken from the record, and the jury would be instructed not to pay attention to it. Also understand that attorneys and clients have a privilege as well. That whatever the client tells the attorney is privileged information. And the attorney is under no obligation to disclose anything their client tells them. Many people don't agree with this, but it is what it is. Because honestly, your attorney should not care whether you are actually guilty or innocent, because that's not up to them to decide. You have the right to a zealous defense, no matter whether you did it or didn't do the crime. Make sense? So make sure you read that section in regard to attorney-client privilege. I think you'll find it pretty interesting. Again, there are some exceptions to the rule. Like I told you before, there's a rule, then there's usually exceptions. Some more court cases here in regard to that. Limits of the attorney-client privilege. Also understand, typically, spouses cannot be made to testify against other spouses as long as they are still married. So all states and the federal government use the husband-wife privilege known as the marital privilege. So the spouse cannot be forced to testify against the other spouse. So basically, pillow talk between husband and wife about a particular crime that one of them may have committed. If they're still married, that one cannot be compelled to testify against the other. But now they can testify. They can choose to testify against the other party, and that in most cases is what happens. But if they choose not to, they cannot be compelled to. All right. Another court case there, State versus Perez, in regard to spousal privilege. There is an interesting exception to this, the partnership in crime exception to husband-wife privilege. It does not extend to situations where the wife and the husband are committing the crime together. One may be compelled to testify against the other in that particular case. So make sure you read that section as well. Or if when one spouse commits crimes against the other spouse or the children, husband-wife privilege does not extend to that far, to that point either. Physician-patient privilege is something that's fairly new in our history. It did not exist at the common law era, and therefore exists only in states that have created such a privilege by statute. So it is considered a very limited privilege, subjected to the interpretation of the statutes of each state. So basically what it says is that a doctor may not be compelled to testify against communication they've had with their patient. But each state's statute is a little bit differently, and some are fairly liberal on what they can compel the doctor to release, and others are fairly conservative. And then there's typically a differentiation drawn as well, whether the patient is deceased or not. Most of the time, if the patient is deceased, the doctor doesn't have as big of an issue talking about more of the communication they had with the person. So make sure you read over that as well. Also talks about the psychotherapist patient privilege. That also was something that's fairly new. It didn't exist in the common law era. A couple court cases in regard to that. Again, some exceptions. Make sure you read over those exceptions to those privileges. Clergy penitent privilege. This is an interesting one. You've probably seen this on TV. About 2/3 of the states have statutes that define privilege between a member of the clergy and a parishioner. And it just varies from state to state. So you can You can read over that section. It's pretty straightforward as well. News reporters privileged not to reveal the source of information. And in many states that is allowed. That journalists do not have to reveal the sources or disclose the sources of the information that they got to write a particular article. Not every state has it. It's kind of a generally accepted thing that journalists do not have to reveal their sources. Some states don't give that privilege, but most of them do. All right. Let's see here. I want to move on to give me just a second here to get to the slide I'm trying to find. We don't have a slide in regard to shield laws, but I want to talk for just a minute about shield laws. Find it in the textbook here. So something I wanted to bring up in regard to that. Typically, shield laws are laws that some states have passed that allow for certain witnesses or victims to be protected, and it may also prohibit, like let's say a rape victim identified her rapist, and the rapist defense attorney digs up a lot of information about previous promiscuity on behalf of that victim in order to try to say this wasn't really a rape, that this was just normal, ordinary behavior for this person, and now she's just trying to get this guy in trouble. There are some states that have enacted shield laws that would prohibit the previous sexual history of that victim from being brought up in a new case that's unrelated to that previous sexual history. So it protects that victim in that particular case, but it kind of throws a monkey wrench in the defense as well. And that's all. I just wanted you to understand what a shield law was, because in discussions this week I asked you to comment on shield laws and what you think of those, and should they exist or should they not exist, and I'd just like to see your opinions on that. So that's really about all I have for this week. I'll see you in the integrity video for next week. If you have questions, reach out. I've got everything up through, I think, Unit 4, Week 4 graded, and then I will be going back in and responding to some discussion postings. You know, typically, if you have already have somebody responded to you, I may not respond to you. Understand, I read all the discussion postings, but I may not respond to them. I'll try to respond to those that don't have any other responses. Even in previous weeks prior to this week, I will go back. So if you don't never had anybody respond to something that you posted, I'm going to be going back and giving you some feedback on that, because I don't want anybody to feel left out. Have a good week, guys, and I'll talk to you soon. Bye bye.